And I get the hour of the day that I need to work extra hard to keep you awake, and I hope I'm able to do that today. My assignment was family law, and when you mention that topic, there are so many aspects that it was very difficult to narrow down. So I listed about 50 things and kept narrowing down to the things that I thought that family lawyers deal with the most. And I also dealt with the issue, if this is faith and justice, we're working with the church community, and if we're zeroing in on divorce issues, how that might be a conflict with some of the congregations and so forth. And it took me back to my childhood. My great-grandfather was a Baptist minister and a lawyer. He was literally both. And there came a time when his congregation sat him down and said, you know, you need to pick. You need to be one or the other, because it's just hard to be a Christian and be a lawyer too. So he chose to continue in the ministry, and I guess I'm carrying on the rest of it. But when you work with the family, you want to remember that the family is actually, in my opinion, the oldest institution, and the constitutional rights that a family has to parent and to be a family are your most fundamental constitutional rights. So keep all of that in mind when you're working with your families. And when you sit down with the client, you want to look at what is in your client's best interest. And when you're looking at their best interest, you're looking at the well-being of the children, if they have children. You're looking at the family unit itself. You're looking at economic stability. And you're looking at another factor, in my opinion, and that is peace. Because, as you know, sometimes clients will sit there and you tell them, you've got a right to this, and this, and they might say, but I don't know if I want to put my children or my family through all of that. I would rather just make this very peaceful. And I believe our legislators that have even looked at that issue when they've suggested or required mediation. And we'll get into mediation in a little bit. But look at all of those issues when you visit with your client. And then when your client says, I just want to have my day in court, I want the judge to hear everything he's ever done to me, then remind your client that, especially if they have children, there's going to be a continued relationship. Getting these kids, the children, through their preschool and kindergarten graduations, high school graduations, college, first job, marriages, children, grandchildren. And what you want to do as an attorney is to zealously advocate for your client, but to also set out a playing field where the family can work together in the future. And you can do that by encouraging problem solving, and I'll talk about that when we talk about mediation. I encourage you to let your words and your deeds, as you're working with the clients in these fields, model how they should behave while they're involved in the legal system, and I think that will help tremendously. Now, what this course is going to cover, I thought I would deal with the most recent statutory changes and new case law, because some of you may have done family law in the past and are not doing it now. And if you pick up an old form or have somebody email you one or whatever, you may be dealing with the wrong issues and the wrong statutes. So I tried to pick things that have very current changes in the law that I thought would help you. So we're going to talk about the parenting plan. We're going to talk about the parental rights and custody and the new best interest standards. We're going to talk about marital dissolution agreements, and you'll probably hear me forget and say MDAs. It's a lot easier. Marital debt, valuation of assets, alimony, and contempt issues. Those are the things we're going to discuss. Now, in the family law, what are some things that you deal with? Let's start with, you deal with custody, right? What else do you deal with in family law? Support, okay? What else? Visitation, absolutely. Anything else? Yes, sir, asset distribution. What else? Debt, all right. What about orders of protection? Modification of prior plans. So there's a lot of things that you can deal with in family law. And I believe it's already been alluded to that a lot of times the people that don't have access to justice, that need your pro bono services and need your help, the very root of all their other problems might be their family issues. And if you can help them with their family issues, then they in turn can be healthy enough to deal with their other issues. Now, your parenting plans, for this, for sure, do not pull out an old plan that you've done a year ago. You need to look at the new form, which the AOC has on their website there, and make sure you use that form, because that form deals with the new parental relocation. It deals with the new best interest. It deals with the new parental rights and so forth. So you are not going to make a chancellor, or according to where you live, what kind of judge hears your case, you're not going to make them happy if you drag up an old plan. I actually talked to Chancellor Butler in Madison County before I presented, and he said that one of his pet peeves is seeing old statutes, old law, old forms, and he's sending them back. And I'm sure your judges and chancellors will do the same thing. So your parenting plan is so important because it empowers the court system through legislation to help the families, and it empowers the parents with the tools that they need to give a better comfort level for parenting their children. And as you know, most children do better if they have the financial and the emotional support of both of their parents. And that's what the parenting plan allows you to do. It's also designed to focus on the child's best interest and establish a roadmap for the future. So when you're dealing with their children and so forth, you've already started a good relationship. It's designed to reduce conflict. And that's so important. Families have enough stresses, and if we can reduce conflict, we've accomplished a lot. It helps with family reorganization, and it reminds the parents that the family, the children, is number one. It enables both of your parents to remain involved in the major decisions. It deals specifically with education, with religion, with medical and extracurricular activities. And it moves away from the old terms of custody and visitation, and it emphasizes parenting responsibilities. And you know, although it's a matter of semantics, I really like that move because custody has a control idea with it. You know, he wants custody, I've got custody. But if you say we have joint parenting responsibilities, that sounds more loving and more nurturing, and that's what you're wanting to do when you work with families. You're empowering both the mother and the father to be a part of the children's lives and the family's lives. Now, the new statutory parental rights are listed, and I've got you the code there, and it clearly says that misconduct is not acceptable, and at the very end, we're going to talk about contempt. If a parent does not follow what they are required to do, judges are dealing more and more with contempt issues and awarding more and more attorney's fees. With a parenting plan, if you're dealing with children and family issues, and this could be before divorce, it could be a modification of a plan or whatever, there are several ways to do this. And you want to do it in your situation. Oops, let me go back. You may have to do it on a shoestring budget. And I have some suggestions that I use that help me. First of all, I let my clients know what the statutory rights are, because a lot of times those are the very issues that they want to deal with, they want to talk about, they want to put in the plan. And when I start with their rights, then they see that the legislators have already set out their rights, and there's less to fight about because they have certain rights. Another thing that I do after I inform them of their rights, then I suggest that we prepare the contract, which is what your parenting plan is, before the judge signs it. At that point, it becomes a court order and enforceable by contempt. But I encourage them to work with me to develop a plan, and then we give it to the opposing counsel or the opposing party, and we pass it back and forth a little while like a negotiation offer and counteroffer, let's say for a real estate deal. And that saves a lot of money, it saves time, and people start learning, oh, well, if I give here, he might give there. And that can move you down the road if you can develop a plan that way. If you can't fully develop a plan that way, but maybe you can get 80% agreement, then you can go to mediation. Now, I also do another thing on mediation to save clients money, and that is an informal type of mediation. If my client and I invite the other attorney and the opposing party to my office, we'll have donuts or refreshments and something to drink and sit down and just try to work out the issues together, face to face, because they're going to have to deal with each other somewhere down the road, and they might as well start now. Sometimes we can develop an entire plan that way and save the cost of a mediator and so forth. If that doesn't work, or if we get a portion of it done and not all of agreement, then we go to the Rule 31 formal mediation and hopefully reach agreement there. And of course, if you can't reach agreement there, then you've got the trial. And I try to encourage my clients, we need to be working together on these things so that you can save money, because the money, instead of lining lawyers and mediators' pockets, would be better served to pay for the children's school supplies and uniforms and college and so forth. So that is the way I approach it and try to see if the parents can start working together more amicably than fighting in court. Now, I'm going to go over some of the parental rights, and the operative word in the amended statute is the word shall. And failure to follow these duties and requirements and actions that the legislators have developed could result in a contempt action like we discussed. Another thing I tell my clients, though, first is this parenting plan is a default plan. Maybe you're even agreeing pretty well right now, but what if one of the parties gets a young husband or wife, and that person wants to cause conflict? We need a plan that will make it through any third party's decisions and attempts at causing conflict. And so I liken it to my computer. I've got an IT man, and I go along using my computer, and I can mess up my computer so badly. I don't know if y'all can or not. And then I'm just going, help, and I call him, and he calmly gets on remotely and pushes a few buttons, and it's back to the default. And I'm going again. And that's what I tell my clients. This parenting plan is the default. If you're working together, and if the plan says you get 2 phone calls a certain night a week, but you're all working together, you can have more calls as long as you're working together on it. But if you're in disagreement, you revert back to this plan. How many have you literally had police or sheriffs come to your office to get a copy of the plan, to look at whose weekend it was supposed to be, and sit down with the calendar and figure out so they can deal with the civil disruption across town because they're fighting over whose weekend it is? Have you had that before? All right, so that's another thing. When we develop our plan, we want to be specific with dates and times and so forth. So if they kind of fall astray of it or reach agreement but then start fighting, you can go right back to that default, and you know whose weekend it is. You know the answers to it. Now, the first thing is the right to unimpeded telephone conversations, and that's at least twice a week at reasonable times and reasonable durations. Now, here's what I suggest, because even if reasonable sounds good to them right now, it might not down the road. So when I'm developing the plan, I like to go ahead and put in the 2 days of the week and the times that the 2 calls will be. And you can put unless otherwise agreed by the parties or something. But that way, if they all get messed up, you can go back to the default and know exactly when those phone calls are supposed to be. And the person with the child at that time had better have the phone available. And the person that's wanting the call needs to cooperate with the time that they agreed upon. Now, the right to send mail to the child where the other parent shall not destroy it, deface it, or censor it. And how many of you have had situations where parents tore up the mail and did not give it to the client, give it to the child? And the child thinks the other party doesn't love them, doesn't care about them, doesn't think about them, doesn't send them Valentine's cards and Christmas cards and gifts and so forth. And that is not conducive to a proper family relationship. And so the statute says that the parent exercising parenting time shall deliver all letters, packages, and other materials sent to the child by the other parent as soon as received, and shall not interfere with delivery in any way unless otherwise provided by the law or court order. And of course, there are exceptions to every rule. And if that needs to be an exception because maybe of the age of the child or because the child had been harmed by the parent or something, then in your parenting plan, you can set out any changes that the 2 parties agree upon. And then, of course, the judge has the right to look at that and see if the judge wants to agree upon that to make it in order. Then another thing is, how many of you have received phone calls saying, my son was in the hospital and nobody informed me? I would have been there. I would have been by his side. Okay, I see that's happened. Well, the plan specifically says that the right to receive notice and relevant information as soon as practical, but within 24 hours of any hospitalization of major illness, injury, or death of the child. And so the parent exercising that parenting time with the child when the event occurs is the one that should provide that information. And not only does the law say that you'll provide that information, but you'll provide the healthcare provider and contact information. Now that's important because many a time a parent will come to me and say, I have no clue who the surgeon was. I have no clue who my child's pediatrician is. I don't know if my child really has asthma and is really supposed to take this medicine because I haven't been allowed to be a part of the child's life. So this is very important. I think the saddest situation that I've had is a man hired me. He had been imprisoned and estranged from his wife and child, and then children. He had a set of twins. And then when he got out of jail and started to make contacts, had difficulty locating them, then was rejected. And about the time he was rejected, one of his twins died. He was not informed until 7 years later when I believe it's about the time he hired us, and we started doing discovery and found out that one of his twins had deceased 7 years earlier. He had no clue that had happened. So the rights for parents clearly indicate that both parties need to be aware of what's going on. Now, school records. A lot of times I'll have a parent call me and say, well, he just won't give me the records. Well, sometimes you have to do self-help. And the statutory right says that the parents have the right to receive from the child's school any educational records customarily made available to the parents. Upon the request of one parent, the parent enrolling the child in school shall provide to the other parent, as soon as available each academic year, the name, address, telephone number, and contact information of the school. Now, in most cases, on that parenting plan, you're going to mark that the parents have joint decision-making regarding education. And that doesn't always mean that happens. Of course, you can deal with that through contempt issues. But the parent has a right to know the school. But then the person that is informed with the school information should contact the school. I encourage them to do it in writing, and it's even suggested in the law here. Do it in writing. Say, I am the parent of this child. Here is my address. Here are some blank envelopes that are stamped and are addressed, self-addressed envelopes and stamped. Would you please provide to me regularly any information on my child? In my opinion, that's the best way to get it. Now, the statute also indicates that the person enrolling the child in school cannot do anything to keep the other parent from knowing. Because a lot of times, what do? They put none on the other parent, or unknown, or address unknown. And then the schools are in a predicament because, they don't know who to contact. They don't know if there has been a order saying that person's not a part of the child's life. So both parents need to work together, according to the statute, to make sure that they both are aware of the child's grades, the report cards, attendance records, the names of the teachers, the class schedules, standardized test scores, and special events in the school as well. And another thing, if a parent complains to you that, well, I never know when the school plays are, when the band's meeting, or the football games and so forth, most schools have all of that on their Facebook or on their website. And if not, then that parent should get to know the coach and directly get that information from the coach. Because also, sometimes with the parent that has the information, they will falsify it, give wrong information so the other parent can't attend, or it's too late or whatever. So both parties need to work together on that. And then going back a little bit to the health, the statute also says, unless otherwise provided by the law, the parents have the right to receive copies of the child's medical, health, or other treatment records directly from the physician or healthcare provider. And that's, again, upon request of the parent. Again, giving the proper name and information and so forth where those records can be sent. But there's something interesting that the legislators have written in here. It says, no person who receives the mailing address of a requesting parent as a result of this requirement shall provide such address to the other parent or a third person. And as you know, because of abuse and so forth, there are times when the actual address of the primary parent is not listed because of safety concerns. And so healthcare providers under HIPAA and under the statute are not allowed to give that information out. Then derogatory remarks. How many of y'all deal with that? He said this, she said that in front of the kids. And that's so unhealthy for the children, isn't it? And guess where the best place to find really if they're doing derogatory remarks? Facebook, text, emails. And they, a parent might say, yeah, we're going to throw some candy out there. A parent might say, well, it's my phone. I can say what I want to on my phone. But how many children borrow their parents' phones to play games and know right how to get to those texts and to see what the parents are saying about each other and so forth? And how many cases have I won by using Facebook and the horrible things that parents have said on Facebook? So warn your clients that that's not appropriate for them, and that in front of the children or where the children can hear, that is strictly unlawful. Then extracurricular activities. I had a case where a mother who had the child about 2/3 of the year enrolled both of the children in baseball in her county. And the father enrolled the children in baseball in his county. And so that meant that the kids could not ever go to all of the practices for either team, could not be there for all of the games. And I filed my motion for contempt. Well, about that time it became school time, and I learned that father had enrolled the children in a school 2 counties away, and mother had kept the children enrolled in the private schools where the children had always been. and neither one would give up. I represent the mother. The judge was not very happy when he had to deal with the issue of the children's truancy in the county with the father, where the children weren't there as often as with the mother, and the children's truancy with the mother because the father prohibited them from going as they should every day there. So anyway, school and extracurricular activities, parents have to work together on these things. For extracurricular activities, the statute says that the parents have a right to at least 48 hours notice of school, athletic, church, and other activities. So that the other parent can participate in and be a part of it. I got in court one time, and the father's attorney showed where the child had been baptized and said, the child should come with me. He's involved in church, and he got baptized 2 Sundays ago. My client, the mother, was not given that information and not given the opportunity to attend. And he thought he was making points on best interest because of relationship in the community, and really he lost points on that because he did not give advance notice, as the statute requires, for knowledge so the mother could participate as well. Now, leaving the state, that's another issue that the legislators have written for us, thank goodness, so we don't have to put it in the parenting plan ourselves. And if a parent is going to be gone more than 48 hours, what is required? An itinerary. And that gives, it used to just say an itinerary. Now it says the dates of the departure, the dates of return, the intended destinations, the mode of travel, and a telephone number. Again, what if you have an emergency and you don't even know your child's out of town? What if the child has an emergency out of town and is hospitalized 3 states away, and the parent doesn't even know that the child is gone? And these are things that the statute says shall happen. Now, the school lunches, when you get to the parenting plans, parents, used to want to make sure they could go to school lunches. The legislators are taking care of that for us too. It says the right to access and participation in the child's education on the same basis that are provided to all parents, including the right to the child during lunch and other school activities, provided that the participation or access is legal and reasonable. However, access must not interfere with the school's day-to-day operations or with the child's educational schedule. And I will tell you, some parents try to use their school lunches to sit and whisper and plan, things against the other parent. And I have actually had schools to contact me saying, this lady cannot come again to our school because she's so disruptive and upsets the child so much. And we hear the conversation, and it's not healthy. Of course, we have to deal with that through the legal system. But now, those are things that all your clients want to talk about. But if they realize that it is in statute, it is there, it is set up for them, it is written for them, then that makes your work doing a parenting plan much less difficult. So I suggest you go over all that first and reassure them these are your rights. And then you can deal with all the other things. And those things that you put in your parenting plan are the number of days that each parent gets with the child. If there's a paramour clause, and we know about the case out of my district, the Western District, where a chancellor was insisting that be in all the plans, but the Court of Appeals has held that it can be in there if the parties mutually agree that there can't be an overnight paramour in the home while the kids are there. So if one party wants it and the other party does not want it, then you pretty much don't get it in there. You can also put things in about drugs and alcohol and consumption of drugs and alcohol. I did one last week that we made special under the other category, dealing with smoking. Had a child with a horrible asthma problem, and father and his new girlfriend smoked tremendously all the time, everywhere. And matter of fact, I was having difficulty breathing in our meeting, sitting across the table from him. The smoke was so strong. And so we dealt with that and put that in our plan as to that he could not smoke in the presence of the child, but had to go outside and had to be very cautious about his clothing and hair and so forth. He couldn't smoke in the car. So you can put things in there as long as both parties agree upon it that help your client. You deal with the tax issue, who gets credit for the children. You deal with who's paying the insurance, and you have to list in there each party's income. So, but once you explain to them what the law has allowed them to do, you can hit those other issues and take a whole lot less time. And then if you cannot reach agreement through passing a plan back and forth, like contract style, or through informal mediation, or through Rule 31 mediator working with your clients, and you go to court, the courts are going to look at the best interest of the child. And the courts have recently spoken to best interest. And I don't know how many of you remember, but, we had a best interest for custody. We had a standard for parental relocation. We had it for termination of parental rights. We had all kinds of best interest standards, and they were very confusing, but yet quite similar. So our recent changes, July the 1st, 2014, have put in 15 factors that are the child's best interest factors. And those factors now are not so confusing, and the judges will look at them. And what I do, if I have to go to trial, and this is some of the biggest things that I deal with if there's children, I go down this list of best interests, and I'm going to give you some practice tips on how to do that. And because I want to convince the judge that it is in the best interest of the child to be with my client. And this is in suits regarding annulment, divorce, separate maintenance, or any modification or any other proceeding in the court that deals with custody of the minor child. Now, yes, we're trying to get away from the word custody, but it's still in the statute a few times. So you will see that even in 36-6106. But the court is going to look at the arrangements that are the very best for the child. And with the new law that was written in 2013, 36-6106A, where it says that each parent should have the maximum participation possible in the life of the child. You look at all of that as you're presenting your case to the court to help the court decide what's in the best interest of the child regarding days and time with each parent. The judge will also look at the location of the residence of the parents. And I'll tell you, I lost a case on that one time. I had prevailed with my temporary parenting plan, and my father, who I represented, the father got at that time it was primary parenting of the child. Mother got very little time, and father got a little cocky. Mother ended up marrying someone in the medical field that was higher of a higher financial status than he was, and he was also in the medical field. And without telling me or asking me, when he saw her new house and where she moved and where she lived, he turned around and bought a house on the same darn street. Now, didn't ask me or tell me, but he was showing her, I can live just as high socioeconomically as you can, Well, guess what? She filed a petition to modify, and the children lived 2 houses apart. The parents lived 2 houses apart. The child could easily go back and forth. They were in the same school district. Before, they were in 2 separate counties. Well, when the court considered the location of the residences and the stability, my client ended up getting half of the time with the child and the mother half the time with the child. So the court's going to look at all relevant factors, but when the court's looking at the best interest, the first thing the court's going to look at is the strength, the nature, and the stability of the child's relationship with each parent. And that includes whether one parent has performed the majority of the parenting responsibilities relating to the day-to-day needs of the child. Now, we're in court now, so I want to give you some practice tips to show that my client has been the one that's performed more than the other parent in these day-to-day events. I'm going to present witnesses. I'm going to present photos. I'm going to present certificates of things that they did together. I might bring in a Sunday school teacher. I might bring in a teacher to show that my client was the one at the parent-teacher conference. My client was the one that had that child at church. My client, was the one more active in the day-to-day life. And what you've got to realize is the judge is going to hear each parent say that they're the one, pick them, they've had the most time with the life. So as the court is balancing this, the court needs more than just he said, she said. So provide evidence if you're in court dealing with this issue. The second best interest factor is each parent or caregiver's past and potential for future performance of parenting responsibilities, including the willingness and the ability of each of the parents and caregivers to facilitate and encouraging a close and continuing parent-child relationship. And how many times have you proven that the other parent couldn't do that, again, with Facebook, texts, emails, pictures, and so forth? So, again, don't rely just on he said, she said. Give the court evidence and proof to show that your client is the one that's encouraging this relationship. Now, if your client hasn't been so good at encouraging the relationship, what I do is I'll watch my client's Facebook. I'll watch them and say, that's not a very good thing you posted. That's not acceptable. I think if the court saw this, they would not feel you are encouraging that relationship. So don't let your clients try their case on Facebook. And boy, I can point to you several that try to do that. But work with your client and remind them it's not I won the child. It is how can we have our child to enjoy both of us and live a healthy, happy life? When it gets too bad, what I will literally do is I'll make my client get me a picture of the child. And while we're sitting there in court or in mediation or just at my office, I'll put that picture on the child in between us. And when they're wanting to have their rights and they're still mad at daddy for this or mama for that or whatever, I point to the picture of the child and say, this is what it's all about. It's about these children. And a lot of you, again, are going to be working with churches, and families need to be encouraged to work together. I remember when I was a child, my dad was a minister, and I went to a funeral, and there are 4 of us kids in our family, and way back then is when the preacher didn't get a salary as much as he got a tenth of the cow that was slaughtered, or some of the spinach out of the garden, or, the corn from the cornfield, and tomatoes, and my parents never complained, but I was quite knowledgeable of the fact that my parents didn't make what my friends made, And a man came up to my dad and shook his hand and said, Douglas Carnes said, I just want you to know you are wealthy. And I was standing by my father's leg, and I thought, wealthy? When did that happen? And he said, you are so blessed and so wealthy. And I'm thinking, I'm not leaving because I want to figure out when my dad came into some money. And he went on to say, I've observed your 4 children and your wife. I've seen your family together. And you are wealthy because you have a wonderful family. And I think about that even when I'm zealously representing my clients, even when the other person on the other side is really and truly a jerk. Kids need all of us if it's safe and healthy for them. So try to remember that, especially if you're working with churches and so forth. Try to encourage each family to be a wealthy family, to have each other. And That doesn't mean you can't fight the fight. My red hair can still stand up straight in court, and I can go at it. But I think it's so important to remember these children are the ones that we do not want to suffer. All right. Then another thing that the court looks at under best interest is refusal to attend a court-ordered parent educational seminar. Now, the statute says that this may be considered by the court as a lack of good faith effort in these proceedings. Now, I don't know what your judges, chancellors do, but get to know them and know what their philosophy is on these things, because that matters. Most of the judges that I deal with, you mark on the plan, yes, each party has completed the parenting class, or one has or one hasn't. And if my client hasn't, but I've got a date, I put my client will attend on this date, and we will provide the certificate upon completion. But sometimes there's parents who just won't go. They absolutely will not go. Now, the other party, one of our chancellors will literally say, if this is a problem to you, visitation does not have to occur until that certificate is filed with the court. Now, some people just don't care. That maybe it's a good father and is just a procrastinator, or a good mother and just procrastinates. And if they don't want to make an issue out of it, the court is not likely to, well, sua sponte, the court's not going to deal with that. But it's very important. I used to apologize. I used to say, oh, you're a college professor and you could probably teach this class, and I'm sorry you have to go to these 4 hours. But I quit that early on because I picked up the material and started reading the material that they learn at that class. And it is very good material. And it essentially puts the children first and teaches them, don't use one child against the other. Don't play these games. Don't use your children. And people of all socioeconomic and educational levels have come to me and said that $50 or $25, whatever it is, 4-hour class was tremendous. So I quit apologizing a long time ago about people having to go to that, because it's an excellent class. Another thing that the court looks at when the court's deciding best interest is the disposition of each parent to provide food, clothing, medical care, education, and other necessary care. Now, how I prove that in court is I get my clients to bring me receipts. If they write checks, I want copies of the checks. If they use credit cards, I make them bring me the credit card bill, or preferably even the receipt that lists everything individually. And we have proof to show to the court, this is what we've done. And if the other party doesn't have it, then that gives considerable weight to my client. And I've heard many a judge say, today was the day you should have brought your proof. Well, make sure your clients work with you to get you the proof so you can present that to the court. And then another best interest factor is the degree to which a parent has been the primary caregiver, and that's defined as the parent who has the greater responsibility for performing parental responsibilities. Now, testimony on this. Bring the Boy Scout leader, the Girl Scout leader, bring pictures of events, bring things, witnesses to show that your parent has been the one that's been primary. Now, some of your judges like the word status quo, and they're not likely to make a change from status quo, as long as it seems to be healthy. So this is a very important factor you need to put on for proof if you're in a trial dealing with the custody of the children. And then the love, affection, and emotional ties existing between the parents of the child. If you listen to cases that deal with parenting and so forth, there's many a time when I leave a courtroom, if I'm waiting on my case to be heard and watching another one, I think I never heard the word love. And to me, that word is so important when a parent is describing how they feel for the child. Not, I did this, I did that, I bought this, I took them there. It's, I love my child. And this is how I express my love and nurture my love with my child. And that is something that the courts are looking for. And again, bring in the counselors, bring in teachers, bring in records that prove prove that you have nurtured and loved your child and guided your child appropriately. Another best interest factor is the emotional needs and developmental level of the child. And again, you can prove this by records. If the child needs counseling and you take the child to counseling, bring the counselor, bring the counseling records, and so forth. Now, the best interest statute also allows for examination of the parents under Rule 35 to present information to the court if necessary to show that the parent may have a psychological need. You can do parenting assessments, you can do psychologicals, and in some cases I've literally had psychosexuals done. And that is to provide to the court, and usually you need to bring those expert witnesses in or depositions of their testimony, because the court needs to see the emotional ties of the parents to the child, and it needs to see the emotional ability of the child, which is another factor that the court considers. And then interaction with siblings, that's another thing. Again, bring your pictures, bring your testimony, bring people to show that your parent is the one who's been interacting with the children if you're in your trial. Continuity in a child's life. Physical or emotional abuse to the child, to the other parent or any other person. And that part is very important for you to bring out if the safety of the child is at issue, and bring the proper witnesses to show if that has been an issue. The character and behavior of any other person who resides in the home. Now, get criminal records on that boyfriend. Look on his Facebook and see what he puts out. You'll be surprised. You'll see him rolling pot. You'll see them drinking. You'll see them drunk. You'll see them talk in detail about their weekend and how they really didn't know where they were, but they spent $500, but they're not paying child support. You'll see a lot of things about a third party that is residing in the home of the other parent that you're going up against, or who frequents that home. Get that evidence. Police reports. Of course, you've got some rules of evidence you have to deal with on some of these things, but get everything that you can and try to put them in, and be prepared with your rules of civil procedure and evidence and hearsay, in case there's a block there. Then the courts can look at the reasonable preference of a child if they're 12 years old or older. And again, know your judges. I've got a chancellor that says, if the child wants to go, I'm letting the child go. Because if I don't, that child will end up in juvenile detention because the child's going to run away and cause so much stress and strife in the home and between the parents that it's not worth it. I've got another chancellor that says, there ain't no kid of no age that's going to tell me what to do, So the point is, the child can talk to the judge. The child can go on the stand and can let their needs be known. But again, the courts use that to weigh the factors as to the best interest of the child. Had one child that I represent, mom. Child wanted to go with daddy. And I knew why the child wanted to go with daddy, because I'd done my homework. And the child was under 12, and the judge went and met with him in chambers. And he asked the child, said, well, what do you like to do with my daddy? He said, my daddy takes me places. He said, well, where? Well, my daddy takes me a part of his motorcycle gang. And it was a group that had a reputation. And he said, and we always eat at Hooters, and I love eating at Hooters. And the chancellor's going, okay. And he asked a few more questions, and guess what? Child stayed with my client, who was in an environment that the judge thought at that time of the child's life the child should stay. But anyway, just do your homework. Know things about the other party so you can give the court the most information possible. A parent's employment schedule. Now, work with your clients on this, because a lot of times the parents have schedules that are where one child wouldn't need a daycare or babysitter if the parties would work together. But now if you're in court and the judge is looking at the best interest, he may be the one to say, because your schedule is this time and your schedule is this time, this is the way I'm going to set up the parenting plan. And it's usually something so obvious that the client should have figured it out a long time ago instead of being before the court to do it. But the courts do look at that. And then any other factors deemed relevant by the court. So all of these things are important things that you have to present to the court to deal with best interest if your parties haven't reached agreement. Now, another thing you're going to be dealing with is marital dissolution agreements. And those, I'm going to move pretty quickly on this. It's kind of odd if they're dissolving the marriage and they're agreeing. I guess you'd call it an agreement to disagree or to disagree agreeably or something like that. But anyway, you want to set out your marital dissolution agreements as specific as possible. And if you're doing it free, don't get in such a hurry that you make it so general that they come back over and over again and do have to pay attorneys or are miserable because they lose their houses and so forth because the plan wasn't specific. I'm going to take one particular thing and let's just look at if the marital home has got to be put on the market. Don't just put, the home will be put on the market and sold and the profits divided equally. How many things do you see there that could cause more litigation? Here's some things real quick. Put in there, who pays the mortgage? Who pays the insurance? What are the damages if the insurance is not paid and the house burns? Who's responsible for the taxes? What if the heating and air unit goes out? Who resides in the home until it's sold? And does that person have to stay in that home if it takes a long time to sell? Who does the yard work? Who does the pool work? What items stay in the house to be sold? What's the listing price? And you should even, if you possibly can, get your high and your low. This is what they'd like to get out of it, but they would take this amount because sometimes they're fighting so badly that you get offers and you miss the offers because the two of them can't agree upon it. Get it while you're doing the marital dissolution agreement. When can the listing be reduced if it doesn't sell right off? What's to be paid from the proceeds before you divide the net? How do you allocate capital gain? What's the procedure if one of the parties kills a sale because they're the one living there and they've got it trashed up horribly where a person that might otherwise be interested in it can't even step through it and there's animal feces and stuff there? What's the remedy if the mortgage is not paid? If one party becomes incompetent, what happens? And is there a provision in there that allows the court to resolve the issue any other issue that arises prior to sale? That's a lot of questions to ask. That's a lot of things to decide. But if you do that, when you're working that marital dissolution agreement, if you get all that down at first, you're going to help create healthier, happier families because there's less to argue about down the road as they hit these questions. And I think that's very important, for us to try to help them set up situations where they're not going to fight so much. Marital debt. Now, what some people cannot realize is all debts incurred during the marriage are marital debt. And Alford versus Alford is a case that gives you more information about that. And the Howard case indicates the factors. Who incurred the debt? What was the debt incurred? Which party benefited from that debt, and which party is best able to pay the debt. And so the court can attribute the debt owed, according to those factors. And you want to do your best to tell the court why the allocation of that debt should be to one person more than the other or divided unevenly or whatever. And the court can't do it if you don't present good information. Now, there is a amendment to TCA 364121H that if an order of protection has been issued, the court shall attribute any debt owed for any batterer's intervention or rehabilitation program to the abuser only. And that's only fair. And but a lot of people don't know that's in there, so make sure you use that. Valuation of assets. Each item needs to be valued by the parties. Now, what I prefer is a Excel sheet, a sheet listing all the assets and listing any debt owed to it, listing who's paying the bill right now, listing enough information all the way down so it can help me if we're informally mediating, or the mediator if we're there, or the court if we have to go that far with it. The court is limited to the valuing the property between the high value and the low value. Now, you may say, my client cannot afford an appraisal. Well, appraisal is going to cost you, according to where you live, from about $450 to $750. But if the person saying it's worth $200,000 and the other person saying it's worth $100,000, it would be worth $750 to get an appraisal, to give the court a figure to look to have before the court. If they're just off $10,000 or $20,000, there probably wouldn't be a need to have an appraisal, because the court, if you get that far, is going to take the median price in between those two figures. You want to have, if you're in court, if you hadn't reached agreement, you want to testify about the property as you go down your spreadsheet. If it's a car, if it's the house, if it's other items of value, like a lot of toys and so forth. The court needs to know the age, the condition, where and when it was purchased, what the parties would pay for it today, and if it's a car, the number of miles and condition. And I use the Kelly Blue Book. I give the judge that as a guideline to go by. And if you're in court, the court needs as much information as possible handed to them during the trial so they can make a good decision. Alimony. If you're dealing with alimony, there is an interesting situation, the maybe versus maybe case, and I think someone here, Justice Clark, could speak to that much more than I could. But when looking at alimony in future, that can be modified, and the modification can depend upon whether or not a third person is living with the party that's getting the support. If there is a rebuttable presumption that's raised that the support that was previously awarded is not needed, and that the third party is contributing to the support. Now, the third party could be an adult child, could be the recipient's mother, a roommate, a minor non-relative, a live-in lover, or whatever. But the maybe case versus maybe case was quite interesting. The husband was not divorced, but he was seeing the wife. He was seeing the party, Miss Maybe, I guess you'd say it. And I may be getting my parties all mixed up. But anyway, he saw her 104 nights out of a year, was overnight there 104 nights a year, but had no intention to get divorced. And so he was not considered cohabitating with her because he was still married and had no intention of getting divorced. Again, if you are in court and you're dealing with these issues, the judge doesn't know what all's going on. You need to have details and proof to show the judge, who is this third party living here? Why are they living here? Are they contributing? Are they just there a few nights out of a year or whatever? So the court can only deal with what you present them. So please, even if you're working free of charge for these people, know the case, know the information, so you can properly present to the court or properly guide them. Now, contempt is the last issue here, and the courts have the authority to punish contempt on cases involving willful disobedience to any lawful order, rule, decree, or command of the court, and one can be punished for failing to act, an omission to perform, or one can be punished for performing a forbidden act. And so the practice point that you should include is to make sure that the standard parental rights and your temporary parenting plan, which I haven't even really discussed there, is so well written that you can deal with misconduct prior to the trial. I'm kind of putting the cart before the horse here. A temporary parenting plan, and a lot of times we don't ever have to get to that because the parties are doing okay at that time. But if you do a temporary parenting plan, it's usually a much smaller version of your permanent parenting plan. But that plan, a lot of times we don't make it specific enough. But if we make it very specific to things that are important to the court, to the best interest of the child, to the child's needs, to the parent's rights and so forth, then while you're getting ready for your big trial and so forth, if the other party does not follow that plan, then you can go right into court for contempt there. And that doesn't put them in very good standing with the court when they're already disobeying a statute, a rule, a court order, and you hadn't even gotten to the final decree. So remember that. Baker versus State has defined the two forms of contempt, and they're civil and they're criminal contempt. Now, the penalty for contempt is usually limited to a fine of $50 and or 10 days imprisonment for each contempt. But for civil contempt, which stems from the performance of a forbidden act, that can result in paying damages, including attorney's fees. And I'm seeing our chancellors more and more and more award attorney's fees for contempt of court. Let's say something we talked about earlier. A parent delivers a package for the other parent to give to the child, or a letter or something special. And that parent, I've literally seen them sell it on eBay instead of giving it to the child. So that parent does something like that instead of giving it immediately to the child. Then that parent can be found in contempt for the provision of the amended statute and may have to pay the parent's attorney's fees for prosecuting the civil contempt action. Now, the Supreme Court has also imposed punitive damages as a part of damages to the prevailing party that's in contempt, and also in the marital dissolution agreement that we just talked about developing, you can literally put in there that a parenting, if one parent does not follow the plan or the provisions of the agreement, that if the other parent brings it to court and prevails, that the non-cooperative party is the one that pays the attorney's fees. So those are things that I always want to tell my client when we're going through the matter, when we're setting up a parenting plan. You don't want to set them up for failure, but when I'm making them aware of parental rights and so forth, when I try to make sure they fully understand what we are doing and have done so they can follow that properly and not be found in contempt of court. And how am I doing on time? Okay, thank you. I can't see back there too well. So I've moved very, very quickly through things that you can deal with in family law. Now, I did not cover juvenile law, and I do a lot of that, but I will tell you the Administrative Office of the Supreme Court has on their website some wonderful CLEs that we've done in the past. Our latest one that we've done is teaching parents, attorneys, how to represent parents very well. How many times have you been in juvenile court and you've seen the parent's attorney not even know what their client looked like, or meet them in the hallway for 3 minutes or something? And we've worked very diligently on teaching attorneys how to be good parents attorneys. There's several good CLEs on that website that will help you. Another thing, forms. Like I said, don't go grab an old form because it might have all the wrong information and improper statutes. But what you do need to do is look on your website for your court that you're going to be in first of all, get the local rules. I have literally won cases because I saw that the local court required certain things to be done before court that the other party didn't do, and procedurally that put me in a good position to prevail. But also look on there for forms. Excuse me. There are free forms. The Chancery Court of Madison County even has forms on there for pro se parties. So it's very, very difficult to do a divorce if you're not an attorney. There's so many things you could miss. But we have put the forms up there, and also periodically our chancellor will ask some of us to come to a meeting and invite people that are having to go through the divorce without having attorneys, and just to give a free evening of instruction, kind of like I've done today here. So use your resources to get your forms. Make sure you know the local rules. Make sure you know the latest statute and so forth. And work hard together to see that we can build healthy, happy communities, but keep the children safe and happy as we're zealously representing our clients, which is a challenge. Any questions? Yes, sir.
In the 15 factors that you mentioned, is it a must that you prove each one of those factors? That's one. And second, is it requirement or recommendations that the judge look at? Because I was understanding to be recommended and not mandatory that you have to prove all 15.
When I'm putting on a case, I do my best to put on the evidence of all 15 statutes. All 15 best interests. But the court does not have to, in the findings of fact and conclusion of law, list every one of them. I do have judges that literally list every factor and say, father wins here, mother does best at this, father wins there. And then will literally say, mother prevailed on 8 of the 15 or 10 of the 15 or whatever. But no, it makes for a longer case if you put them all on and put witnesses to help your proof. But those are the things that the court is supposed to look at, and the court does not have to include in their order that they've ruled on every one or even heard the evidence on every one. But those are clearly the most important things. And I'm not sure if I got both parts of your question with that answer.
Well, I was wondering whether or not they were recommendation or were they mandatory that you had to prove, because, again, I was under the impression that there were recommendations that the court used in making a finding of determination who should get custody.
Right.
Well, not custody, but, because that's outdated.
Best interest.
Best interest.
I think the court is required to look at those best interest standards. I don't think the court is required to indicate in the order that they've ruled on every one of them. And I think a lot of attorneys will skip over some of them that are not so easy to prove or are not so important, or that if a court balanced it out, it would be equal. So, no, it's not a requirement that everyone be considered and that everyone is named in that order. But those are the factors that the court is supposed to weigh as it determines the custody of the child. Does that anybody have any thoughts to the contrary on that? All right. Any other question? Yes, sir.
One of the things, because of the Faith and Justice Alliance, that you might go over are the court-approved forms for pro se divorce. I've had several instances where we've had folks in a mission clinic or something like that who qualify for those forms, so you might touch on that. Okay.
And that's when you need to check your own. The party needs to check in their jurisdiction first, because many jurisdictions have pro se forms for complaints and so forth right on their web page. They can pull it off, print it, and fill in the blank. Now, the problem is I actually talked to some court clerks last week, telling them that I'd be here talking today, and asked them about their pet peeves. And they said, our pet peeves are so many people fill in the blanks here for these forms, but they don't have a clue what they're doing. And they set up for more litigation, or we can't give legal advice, although we know the answer. And then when they get to court, then the chancellor or the judges, have to deal with those issues. And when I told her that we were meeting today to train more lawyers to help, the court clerk in Madison County was very excited and hoped we have a lot of attorneys to help in Madison County for that very issue. But their forms are available, and I'll even say, if the parents have filled out an indigent form and have qualified, it's my understanding that the parenting class that costs from $25 to $50 in my area, that fee can be waived. So if they're indigents, if they can't afford attorneys, if they don't have somebody like you to help them, there are forms available to them, but it is quite a challenge to get through. Any other questions? You know that the relocation now is 50 miles, not 100 like it used to be. So don't let your parenting plan have the 50-mile relocation on it. And let's see, I'm trying to think if there's any other changes. I believe that probably covers most of the most current changes that if you haven't practiced it for a while, you would need to know. So God bless, help our families. Thanks for being here. It's wonderful to have people that care and are concerned like y'all do. And thanks to our Supreme Court justices for seeing the need for this and for sponsoring it and for helping us to network and work together on this.